Hi, I'm Nikki. Welcome to Relitigated, the show where five friends who are absolutely not lawyers attempt to retry a real Supreme Court case. This is episode 8, North Carolina v. Alford. Two quick notes before we get started. First, as always, we try our best to represent the facts and decisions in the case as accurately as possible, but we're not lawyers, and nothing in this episode should be taken as legal advice. Second, if you enjoy the podcast, please support us by subscribing, rating, leaving us a comment, and telling your friends. Help us get the word out. If you like, you can also find us on YouTube and Instagram. Our handle is Relitigated Podcast. Thank you so much for your help. Okay, with that out of the way, let's start the show.
Oh man, I'm so excited to not be the most insufferable one here tonight.
Did this just turn into a science podcast?
Oh.
So on that note, welcome to the Relitigated Podcast. I'm your host, Nikki, and I'm joined by my co-host, Jarrett.
Hello.
We also have with us three justices, except they are not justices or lawyers or legally formed at all. First, we have our first-time Associate Justice, Mike.
Hello.
Then we have Associate Justice Chris.
Hello, not a lawyer.
And of course, we have our Chief Justice, Sarah.
Hello. Also not a lawyer. And neither is Mike, might I add.
Oh,
To be
yes.
clear.
Yeah, absolutely.
But I am a judge.
Aren't we all?
So Jarrett and I, also not lawyers, we have picked a real Supreme Court case. Our justices do not know what case we have selected. Jarrett will introduce the case to us and walk us through the details, and the justices are free to ask factual questions during this time. Next, we'll move into oral arguments, where today I will represent the petitioner or the appellant, the person complaining, and Jarrett will role play as the respondent or the appellee. We each get 7 minutes to make our case, during which the justices can interrupt us and ask us questions. When the arguments are over, the justices will deliberate and deliver their own opinions. The final rulings do not need to be unanimous. Majority opinion wins. Even if two or more justices agree in principle, they can disagree as to why. Once we've finished our hearing and Sarah's court makes a ruling, Jarrett and I will reveal what the Supreme Court actually decided and talk about how we feel about the actual results. And with that, Jarrett, please introduce us to our case for today.
Yeah, definitely. So our case for this episode is North Carolina v. Alford. It begins one evening at what is known as a party house in Winston-Salem. If you're curious what a party house is, so am I. As best as I can figure from doing some quick Googling, it's a commercial establishment where people can gather to party and socialize, kind of like if you went to a bar or a club, but it was set up more like a house with separate rooms and such. That's the best I could figure out. I'm sorry. Anyway, after answering a knock at the door, the operator of this particular party house was struck down by a single shot of a shotgun. Following an investigation, a gentleman we will refer to as H.A. was suspected of committing the crime. Apparently, earlier in the evening, H.A. had come to the party house with a female companion and rented a room, but they left the room very quickly, supposedly because H.A. had no additional money. On the way out, H.A. demanded that the woman leave with him, but the operator stepped in and said that she could stay if she wanted. After an argument, H.A. ran off with the woman's coat, and 15 or 20 minutes after that, the operator was shot dead. H.A. was indicted on a charge of first-degree murder, which in North Carolina is a capital offense, which means it could be punishable by death if he was found guilty by a jury. In his defense, H.A. gave his lawyer a list of several witnesses that could vouch for his innocence. Unfortunately, after questioning all but one of them, his lawyer discovered that they, quote, gave statements that strongly indicated his guilt, end quote. One witness stated that H.A. said aloud that he was going to kill the victim, who he identified by name. H.A.
Oof.
then allegedly kept repeating that he was going back to the party house before retrieving his shotgun and 4 shotgun shells and then leaving. A second witness saw H.A. walk by with a gun, and about 30 minutes he saw H.A. walk by again, going the opposite way, this time stating that he had shot the victim.
Perfect.
A third witness was a neighbor that H.A. told, quote, "If the officers come looking for me, tell them I haven't been here," end quote.
This is amazing.
The officers did come looking for H.A., and afterwards the neighbor asked H.A. why he had asked him to say what he did, and H.A. allegedly responded that he had shot a man.
Perfect.
Oh, yeah.
Can't wait for the drop to realize how whatever is going on here gets to the Supreme Court.
Yeah. Finally,
Seems very cut and dry.
Finally, a woman recounted that later in the evening, H.A. had bought her 2 drinks at a bar and told her that he had shot a man and would be going away for a long time.
Oh my God, I love this guy. He is just so honest.
Is this a Johnny Cash song?
Feels that way. Given the strong evidence against him, H.A.'s lawyer suggested to him that he plead guilty to second-degree murder. If he didn't, and a jury convicted him of first-degree murder, then he could face the death penalty. Ultimately, though, the decision rested with H.A., and he chose to plead guilty, though he asserted that he was innocent. The prosecutor accepted H.A.'s plea, but the judge decided to hold a hearing before the court accepted the plea. A police officer and 2 witnesses testified, essentially walking through the charge that following an altercation, H.A. returned home, stated he would kill the party house operator, retrieved his shotgun, returned to the party house, and shot the operator. H.A. also took the stand at the hearing where his lawyer asked him questions about why he was pleading guilty, and he stated that it was to avoid potentially receiving the death penalty, but that he was actually innocent. The court then asked H.A. if, given that he was claiming to be not guilty, he really did want to enter a plea of guilty for second-degree murder, and H.A. confirmed that he in fact did because he wanted to avoid the death penalty. With that, H.A. was found guilty by the court and sentenced to the maximum of 30 years imprisonment. Following his conviction, H.A. would appeal to the state's appeals court, arguing that his guilty plea was the result of fear and coercion. The state court disagreed, however, finding that H.A.'s plea had been, quote, willingly, knowingly, and understandably, end quote, made. They also noted that H.A. had followed the advice of competent counsel and that the prosecution's case was strong. Undeterred, H.A. appealed twice to federal courts, first to the district court and then the Court of Appeals. They each rejected H.A.'s appeal, finding his plea was made voluntarily and that he had effective counsel. This did not stop H.A. from appealing yet again, and while the district court once more denied the appeal, the Court of Appeals for the Fourth Circuit reversed H.A.'s conviction on the grounds that the threat of the death penalty forced him to plead guilty. This reversal was appealed to the Supreme Court, and so it falls to us to take up the case. So our question for this episode is a guilty plea invalid when the defendant is also asserting that they are innocent and only pleading guilty to avoid the death penalty?
Well, we're going to find out.
Because we're going to answer the question.
Yeah. And then they're going to tell us at the end
So also because
what
the
the
hosts are going
actual
to tell
ruling
us.
was. Yeah.
Also true. Also true.
So I have to ask if there are any factual questions, but about halfway through reading witness statements, I wasn't sure that there were any facts that were left to be uncovered.
Yeah. Just circling back one time quickly on this, did he say that he killed a guy? Was he saying he wanted to kill a guy?
At which point?
Exactly. Probably many points, right? Yes.
He was alleged to have said in front of witnesses, but in court,
multiple witnesses.
he denied.
Right. Okay. You put alleged in front of anything these days, and it just changes the whole vibe. I mean, I'm good if we want to keep going.
I don't have any specific questions.
I'd like to learn more about party houses, and maybe we should have gone to one for research purposes. But
that's a good idea. We should have to circle back on that later.
Yes, the court wants to see a party house.
Poor planning.
I think sounds like we're probably ready to get to the sounds like we're probably ready to get to oral
No, let's
arguments.
deliberate. You know what? No arguments. Let's just
Screw
go straight to deliberations.
Yeah.
No, argue if you must. I am ready to hear arguments.
Oh, you haven't already immediately taken the side I'm not going to argue?
Doesn't know
Well,
what side that is yet.
Honestly,
That's fair.
honestly true.
that's fair. Time will tell. Nobody's safe.
Okay. Well, Nikki, I am prepared to start the clock whenever you begin. So the floor is yours.
Okay, I am ready to begin, and I will be taking the position of the state of North Carolina. So, Chief Justice, Associate Justices, H.A. had an attorney who consulted with him on multiple occasions, as well as with his sister and friends. The lawyer laid out for him very clearly his charge, his right to a jury trial, and the potential punishments for first-degree murder, which include life imprisonment or the death penalty. The lawyer also went over with him his rights to appeal, including before the governor. This all means that H.A. knew his situation. H.A.'s lawyers could certainly give advice, but could not make the final decision about how to plea. That was up to H.A. And H.A., in this case, gave written authorization to the defense lawyer to enter a plea on his behalf and did that written authorization with witnesses. He also made the decision to plea by his own free will, just as he exercised his right to appeal in this case. And when he took the stand, he testified that he was aware of what he was doing and why he was doing it. Although he has stated that he is innocent, H.A. is essentially engaged in a plea bargain. His movement through this process involved being aware of the options available to him, identifying for his lawyer information relevant to the case and potentially to his defense, assessing possible outcomes, and then making a decision in light of his goals and his legal interests. He did all of that with an interest in not only avoiding the death penalty, but also to get a sentence that allowed the possibility of release. In this case, there was a lot of evidence against H.A. There were several witnesses, including people who knew him and were familiar with him. The fact is, the state had a strong case against him. And sometimes all of the options realistically available to a defendant are undesirable. This is an individual who is in a bad spot. Just because the state has a strong case and basically that the evidence shows that it is more and more likely the defendant committed the crime as alleged, does not make the case coercive. It's not coercion just because the objective facts are not how you like them and they disprove your defense. H.A.'s decision to plead guilty is an exercise in pragmatism. He was reasoning through his case, he reasonably predicted outcomes, he problem solved, and he determined a course of action. During the criminal process, the government can certainly protect your rights, but it cannot protect you from consequences of your behavior or from the trail of objective evidence casting its eye upon you. And because this case is so straightforward, because it was so clear that he knew what he was doing in making his legal decision, that is the conclusion of my argument. Thank you very much.
Wow, short and sweet.
Mm-hmm.
Yeah. I
I have no questions.
Yeah, no,
that's kind of what I was thinking.
Yeah.
I was like, yeah, I mean, he kind of knew what he was doing, right? But anyway,
Mhm.
I have no factual questions or
the court was too stunned to speak.
Well, yeah.
Yeah, I don't have any factual questions that I need cleared up either. Pretty sound argument. Jarrett, once again, I mean, we find ourselves at this crossroad. Right?
Once or twice.
A couple times now.
I'm gonna stop the clock for you, Nikki. You still have about just under 3 minutes if you want to reserve your time.
Yeah, I'll reserve my time.
For the folks at home, the idea is one of the folks who are arguing, if they don't use all their time, they can reserve it. So when the other person goes, optionally, the first person could use the rest of their time after. So it's like an opportunity to sort of go before and then after if you have time left over. So that's what Nikki's
Like
going to
last
do.
licks.
I mean, she might not end up feeling like she needs it. And based off of what the justices just said about her argument, she may not.
Or she may.
Do you feel coerced to reserve your time to avoid any penalties?
Absolutely not. I make this decision freely, and I have the right to use or not use as I see fit.
All right.
There you go.
Nice.
Nice. Thank you, Nikki. That was great.
Thank you, Your Honor.
There's got to be some objection or paperwork I can file at this point.
No. Everything is fine.
What do I have to do to have someone call me Your Honor?
Well, you probably got to get your hands on a
Technically.
powdered wig first.
Oh, yeah, true.
Oh,
Yeah.
shit.
Make it
Yeah.
real sticky.
We didn't tell you about that?
No. I was just dragged off the street and given a microphone.
Yeah.
That sounds about right. Yeah.
Yeah, that feels right. It's okay. You'll get there one day, you know?
All right.
Yeah.
Well, I am prepared to be treated like a hostile witness whenever the timer is ready.
All right. Woo.
All right, and it will begin once you begin.
All right, let's do this. Miss Chief Justice, and may it please the court, I submit to you that the guilty plea entered by H.A. was won by the state of North Carolina through coercion and fear. In order to escape death, which any of us would do, H.A. had no choice but to volunteer himself for 30 years imprisonment without due process. All the while, H.A. asserted that they were innocent of the crime as charged. Imagine being accused of something you didn't do, and the state says, well, we can go to trial and you can try and prove your innocence, but if it doesn't work out, we're going to kill you. Alternatively, take this plea deal and you live guaranteed. None of us would be thinking rationally in that moment. You would be so consumed by fear as you realized it was you by yourself versus all the resources that the state could muster against you. You would have to waive your rights to save your life. And no matter how loudly you professed your innocence, the state would accept your plea and the prosecutors would notch another win on their belt. This good cop, bad cop approach that the law takes is a clear violation of H.A.'s Fifth Amendment rights. The burden is on the state to make their case, and the courts should only be interested in vigorously finding the truth. When a man stands before you and says they are innocent, but if it saves their life, they'll say they did the crime, then the courts have a duty to determine what is reality instead of ignoring the contradiction and just moving on. The implementation of North Carolina's laws incentivize defendants to waive their rights to a jury trial. With all the power that the state has, it is the responsibility of the courts to protect us from the state, not to be complicit in rubber stamping its desired results, especially when someone stands before them, and says that they did not do it. We certainly cannot entertain that this plea was entered voluntarily. No man staring down the possibility of execution is really being given a choice. I would go so far as to say that the threat of death is enough to put someone into a headspace where we can no longer consider that what they do or say is the result of a reasonable mind. If you are looking for a comparison, look no further than torture. The louder you voice your innocence, the harder the torturer puts their screws to you. At some point, the pain and fear are so great that it doesn't matter that you're innocent. You will say whatever it is that the torturer wants. In this case, the torturer wants you to plead guilty without making them prove it. And so H.A. relented. But we all know that torture seldom yields the truth. Lastly, I am concerned about the divide that this approach to law creates between the haves and the have-nots. We have created a system in which an individual with means is better able to resist the state by affording better and more lawyers and experts. Those lacking in finances, such as H.A., can't fight back with the same power. The result is a system where prosecutors can disproportionately coerce our poor countrymen and women into waiving their Fifth Amendment rights. Make no mistake about it, this puts an enormous amount of power into the hands of prosecutors. The death penalty is not the only thing that prosecutors can use to put a defendant in an impossible situation and get them to do what they want. The bending of a defendant's will through what is essentially false choice is very easily done.
Question.
Go ahead.
Would you then say that it would be more appropriate to not allow guilty pleas in the courts?
A guilty plea is fine, but when the choice...
Like a plea deal such as this, right? Like, because a lot of people take guilty pleas in order to avoid the death penalty. I mean, innocent or not, I would think.
In a
Do you think that
situation,
shouldn't be an option?
in a situation where the prosecutor said, I'm going to charge you with first-degree murder, and when I try you, the state is going to kill you, and then you come back and say, well, what if I just plead to second-degree murder? And the prosecutor's just like, yeah, I'll take that win. Then the prosecutor was always okay with an option short of the death penalty.
Sounds like a pretty shitty prosecutor.
But it's the representative of the state using their power and their wide latitude to put somebody into a position where they didn't then have to really do much extra work. They can do that to anybody. They can do that to any of us at any time. And the poorer of us don't have the means to fight back against the state in that situation. So whatever you think of my specific client, H.A., you have to think about it beyond just this particular individual. They could do this to anybody, regardless of what the evidence is. And once you put the choice in front of somebody between the resources of the state trying to prove that you're guilty, and if they accomplish that task, they can murder you. I don't think that's a choice anymore for the defendant. I think the defendant has to take the plea deal. And if they have to do it, that's not due process. That's a violation of their Fifth Amendment rights. And that's an overreach of the state that cannot be justified.
Fair enough.
It is our belief that the state court acted in error by allowing the state to cajole H.A. into waiving their rights, and as such, H.A.'s conviction must be thrown out. If the Fifth Amendment means anything, if no one can be deprived of life, liberty, or property without due process, then we must acknowledge that this good cop, bad cop routine cannot be allowed to continue or to stand. With that, I yield to questions.
No questions. I think that the guilty plea itself, he was, I think he made peace with what he did.
He always asserted innocence. It was the state that ultimately put him in a position to save his own life, to just say, all right, fine, I'll sign your paper, but I'm innocent.
I see. Okay. So, but he in the heat of the moment, right, in the act, he kind of made peace with what I meant is that he made peace with the people that night, and then as part of his testimony,
it never went to trial. It never got to the point where we could interrogate his mens rea, his state of mind. We never got to interrogate his competence to stand trial, or his if he had an altered mental status. We don't know any of these things because
and you are at time.
Hate to see it.
Okay. Well, yeah, I understand. He never actually testified because there was no jury, there was no trial, because he took the guilty plea.
He did testify, and actually, I would like to use some of my remaining time.
Oh, please.
Snap.
Yep.
Let's do it.
Go ahead.
Welcome back, Nikki.
So, an individual certainly is vulnerable against the resources of the state. And for that reason, a defendant is entitled to due process. So, due process granted him a lawyer, granted him the opportunity for a trial, granted him knowledge of the evidence against him, the potential to confront the witnesses against him, and the opportunity to consider his options. Once again, his options were limited by the evidence of his guilt, including from the witnesses that he identified for his lawyer. The state did certainly present their case in front of the judge for the record, which is what the court is relying on now. He did not have a trial, but before the court would accept his guilty plea, the judge wanted to hear just a summary of the evidence. So that was presented. The judge also wanted to hear from H.A., who confirmed that he was making this decision to plead guilty consciously, with knowledge of the potential consequences, with knowledge of his rights. The death penalty was certainly an option, but not a certainty, even with conviction. So H.A. asserted his innocence while weighing his options and potential outcomes, so basically engaged in decision-making and making the best of a bad situation. And with that, I will yield to questions.
I don't think... Oh, go ahead, Chris. Go ahead.
Well, I was going to say no factual questions. I can see both sides, right? Where the HA was testifying, but doing it out of I'm going to save my life based on the very smart people in the room. But on the other hand, he was consciously making the decision. It's almost like his testimony is evidence that he was of sound mind. But yeah, so it's tough, I guess. I can see both sides.
Truly a rock and a hard place that HA is in.
HA was definitely in that, yes.
Yeah. Although he may have legitimately killed a man, so that's... You shouldn't
also
do
true.
that.
Did it to himself.
Yeah. You shouldn't do that, people. Let's not do that.
Not ideal.
There you have it, folks. You've come to our decision. Don't kill people.
Don't kill people. Okay. I don't have any questions for you, Nikki. I think we should be good. Michael, do you have any questions before we get into our own deliberations?
Got thoughts, but no questions.
Okay. All right. Well, guys, it's time to get into the thoughts.
All right.
I don't have organized thoughts, but they're there.
Oh, me neither. I mean,
me all the time.
Yeah, nothing's been organized on this show thus far, besides the sequence of events, I would say.
All right, Nikki and I will activate clerk mode.
You need like a magical wand sound effect right there.
Yep.
Indicating you turning back into clerks.
Some Voltron sound effect or something.
You can make it work.
Transformers. We need the Transformers sound. Yeah, exactly. Yeah. Oh God, it hurts. Fall that way. I'm sorry. Please just deliberate.
We're full of bones here.
Okay.
We're all full of bones. We get it.
Okay. Bones aside, I'd like to start with an opening thought of my own that I have. And that thought is that we should just abolish the death penalty in this court. Because I feel like if HA or other defendants were not faced with such a grisly end, if, their lawyer does a terrible job of arguing for them, then they would feel open to actually pursue trial, and the courts would maybe be able to do a better job of uncovering the truth. What say you, associate justices?
Yeah, I mean, I get it morally, right? It's a tough moral decision, but there's also like, well, this guy killed someone and then was
allegedly.
like, oh shoot, yeah, allegedly, and by his own testimony,
fair.
ish. And so, he's afraid of dying, so he's going to plead guilty and then serve 30 years in prison. And so I don't know. You don't want to be like, oh yeah, you're right. Let's take the death penalty off the table. You killed someone. Sure, you're right. That's kind of scary. Let me take the death. So like, I don't know if that's the right move. I feel like it's more or less, it's a deterrent to killing people. So you probably don't want to do that. So
for anybody listening, if you had any doubts, We are
Probably not.
imploring you to not kill others. Okay.
Not ideal.
Yeah.
Also
let's
not moral.
Yeah.
Bad. It's bad.
Just seems like a lot of work. And you don't want to get yourself in that situation.
Jeez.
Okay.
So I think I'm behind getting rid of the death penalty, but unfortunately, I don't think that's the question here.
It's not,
Never
but it was
is.
just
Yeah.
it
Never
was just
is.
the thought at the front of my head right there. I
It is
had to get it out.
it is the inciting incident. Without the death penalty, I don't think we're here right now.
Correct.
That's true.
Okay. I feel like my gut is telling me at this very moment that I don't think that this guilty plea, wow, listen to me, is just automatically invalid just because he says that he's also innocent. Like, I feel like, to Nikki's point, he was legally, while the death penalty is a horrible way to go, he was legally informed of his options. And do I feel like maybe it's kind of shady and could hurt people who really are innocent and are just taking a guilty plea to save their own head? Yeah. But do I think that that makes it invalid? In this case, I don't think so. He seemed kind of like he did it, so I don't know.
Okay, so maybe I do have a question. So his guilt got overturned, right? On this last appeal that he did, or the
That is correct.
conviction.
Yeah, the
Does that
lower
mean
court.
does that mean like he's absolved, goes free completely?
Well, North Carolina appealed it to the Supreme Court, so it hinges on the decision that you guys make.
Okay, so if we say that it should be overturned, then he is like walking a free man.
Well, you can send the case back down to a lower court to like redo like the trial or whatever, and you can be like, this is the new rule that we are implementing starting with this case. Okay, lower court, now go back and do it again, but right this time.
I
Okay,
am
so
wondering, though, if double jeopardy would attach at this point.
Oh, well, then in that case, I guess he could appeal it back up to the Supreme Court.
Yeah, because my original thought was, okay, maybe it gets overturned here because he pleaded guilty under duress or coercion, but instead of going free, that means like, okay, we have a trial. But that might be the double jeopardy thing.
So my gut, not a lawyer, turns out, but my gut tells me that the state wouldn't have the ability to try him now.
That's
Yeah,
true.
I think so.
Well, I mean, ability to gather evidence in that might have passed also.
Yeah.
We could be a period of time henceforth which witnesses are not around anymore or have passed away.
Yeah, I'm even thinking like physical evidence.
Yeah, obviously you don't know what the year is of this case, but
yeah, I don't.
But I can tell you that it's been since the alleged offense, it's been just under, so it's been about 6 years.
Okay, so we're hearing this case 6 years since the incident happened, or since he got convicted?
Since the incident happened.
Okay.
At this point, he's been in jail several years.
So he's already serving that part of that sentence.
Yeah.
So many facts.
There's a lot of obvious things that we're like, yeah, if you kill somebody, you're probably not in a good spot. Not ideal.
The last episode I listened to, you guys were talking about apple cider vinegar, and here I am thinking it's going to be this light, fun thing.
Yeah. Welcome.
Welcome to the Thunderdome.
Join us. Really, we never know what we're going to get. The apple cider vinegar was a levity break that we were all very surprised about. So
Yes.
Clerks, bring us more cases regarding food. Okay.
Also, clerk, if you could bring me some apple cider vinegar while I deliver it.
Or an apple cider donut.
Ooh.
Dip it.
Yeah.
Focus up. That was
sorry. Okay. All right. Okay. Yeah, I don't know. I feel like there's a lot of obvious facts in this case. I do concede that there is like risk in anybody taking a plea deal, in that if they really are innocent, but they just feel like the facts are stacked against them or their lawyer sucks or whatever, the plea deal is the best way to save their own skin. But I also don't really like the idea of just throwing this guy's case out without like a clear path to an actual legitimate trial to see if he's like, if he can really prove his innocence, you know?
Yeah,
Because
it seems like getting away with it on a technicality.
yeah, which is dumb.
Yeah, that's exactly how I'm feeling right now. It's like I don't want to overturn the guilty plea because he obviously, I mean, his testimony and the two witnesses as well. I mean, there's a lot there, and the fact that he basically went all the way to the Supreme Court and is now like, oh yeah, no, I'm totally innocent. Don't worry about it. And then he's like, well, we'll send you back to trial. Oh wait, no, we can't try you again. That's like, he got away with it somehow legally.
Wait.
Somehow.
Question. Maybe it was already answered and I missed it. But did he maintain his? Oh, okay. This actually might be the stupidest question I've ever asked. But he maintained his innocence throughout, like all courts that this case has been through, right?
No,
Yes.
Never faltered.
Never faltered.
Never.
So how are you able to? That's weird to me that you can maintain your innocence yet still officially plead guilty.
Well, it's like, I mean, we've all seen. Well, I don't know if you have, but like any lawyer type TV show.
Yeah, I'm not
You
saying
do
I
that all
don't
the-
get that it happens. It just boggles my mind that that's allowed.
If I'm not mistaken, which I'm sure we might talk about this at the end. I don't want to spoil anything. Jarrett, please feel free to cut this out if you would like. But this is like a thing. This is like, I'm pretty sure this case is like a big thing in a, what am I trying to say? It's like the big backbone as to why people take plea deals and also say that they're innocent all the time just to save their skin. And I think this is the case that founded that. I think.
Yeah. So people do take plea deals to get lighter sentences. That's pretty
Right.
common.
But then it's like, I hate the idea of people doing that. Like people who are legitimately innocent doing that because the odds are stacked against them and the state's resources are super robust compared to, if you don't have any money for a lawyer or something. I don't know.
If he's asserting that he's innocent and pleading guilty to avoid the death penalty, then he knows something that the risk of death is very high. The risk of getting that sentence from the judge is high, which kind of, if he's truly innocent, then he has nothing to worry about.
Well,
right?
maybe not because I don't know about that.
No, I don't know. Okay, see, in a perfect world, that would be correct, right? But I feel like there's so many instances where somebody is like, they're legitimately innocent, but they don't have maybe the resources, or there's like really weird circumstantial evidence that puts them in a bad place at a bad time, and like they're being framed or something like that. I feel like we hear about people getting wrongfully convicted all the time.
Yeah, I was gonna think about once DNA became a thing and they retried, how many people that were on death row that got exonerated. Plus you could get maybe a crappy public defendant that doesn't know what they're doing.
Oh, it's all bad. Just don't kill people. Don't put yourself in this situation.
Yeah.
Or don't be in the vicinity of somebody else being killed to where you might accidentally get blamed.
Words of wisdom.
Yep. That's why I am the Chief Justice, by the way.
That's true.
It's true. That wig.
Yep.
I'll get mine someday. But I think we need to try to take ourselves out of the specifics of this case. And I guess we're trying to make a general rule that would apply, right? Because whatever we come to here is going to be applied, not necessarily just to murder cases, but other cases where people can plead guilty, right?
Yeah.
I personally, I mean, where I am right now is that the guilty plea is not invalid. The guy is obviously, he's saying he's innocent he's saying he's innocent because he wants to save his ego or something, but he's like, no, I'm going to plead guilty because I'm totally guilty. So I don't think the guilty plea is invalid. That's where
I think I agree. Like in this case specifically, I don't think that this should be invalid. Like I don't think we should just throw it out. And I feel like there's probably a lot of other cases out there where like, no, we shouldn't just throw it out. There has to be like, is there like some sort of caveat? Like, can we fix this system in our little fake court that we have here? Like, I don't know.
We have in the past.
We need like a porque no los dos that we can apply to this, but not call it porque no los dos. You know, like something is wrong and something needs to be fixed in order to safeguard people who really are innocent. Like I don't know if we just need to like beef up like our public defenders or like, I mean, I don't know.
I think it goes to your original point of potentially abolishing the death penalty, right?
Yeah.
I think that's the, I think that's the question.
Because that's the big one, right? Like if you're facing like 30 years in prison, yeah, that sucks. That's real shitty. But like if you're facing death, that's like way shittier, I feel like, at least in my opinion.
Yeah, I mean, are we allowed to abolish the death penalty here? Is that a ruling we can make?
I mean,
we're
the
yeah,
law.
Whatever we want.
I think you could. I think it's within the power of the court, the highest court in the land, to say, you know what, we're looking at it and we are overturning the state's right to have a law that allows for the death penalty.
Because I mean, like, let's say this is like some white collar crime and not a murder at a party house. Like, we wouldn't be here right now.
No,
this would be a non-issue.
Yeah, if this is like embezzlement,
no, you're guilty. Like,
yeah,
just to do the time.
Yeah,
that's my thing. Is like I don't want to get this guy off scot-free because of a technicality over him potentially being coerced and then not being able to retry him due to some other weird rules. I think that's just cheating for killing, and he killed the guy, so he should be brought to justice.
Yeah, I agree. He seems
allegedly. Allegedly, based on two witnesses potentially, and his own testimony.
He's sketchy. Like he should not be wandering the streets if he actually did kill bro, which it seems like he did.
Definitely killed a bro.
I mean, if you're going to a party house anyways with a female companion, I feel like you're already up to no good, So
True.
Who's killing people at party houses? Party houses are like good time, high vibe places.
HA is killing people, allegedly killing people.
Forget murder. Man is guilty of a party foul.
It's true.
Just a quick factual correction. Chris, you've said his own testimony. When he testified, he said, I didn't do it. And he never testified that he did do it. So,
but he
this is a witness testimony, maybe.
He pled guilty. He said, I'm pleading guilty, but I didn't do it.
Yeah, it was all the witnesses, the multiple witnesses who were saying he did it.
So basically, the lawyer was like, "You got no shot here, buddy."
The lawyer was like, "Hey, bro, I cannot help you with this."
Yeah, that was the advice of counsel. I do. This is the part where not being a lawyer kind of is a legitimate problem for us, because I don't exactly know how this would work. But here's how I think this would work. If you wanted to say no death penalty, I think what you have to do is you have to strike down the law that he was convicted under.
Oh no! Does that mean he goes free?
Do that, he goes free.
Murder,
oh yeah,
murder is illegal.
And then every state
second
that
degree murder is legal.
Every state. Well, actually, he wasn't convicted under first degree murder, though.
It was he pled guilty to second.
He pled guilty to the second degree murder. So I think you might, but I think what you would do is you would free all the first degree murderers and you would leave this guy locked up.
Well, I mean, couldn't we get rid of the death penalty under cruel and unusual punishment grounds?
You could, but the way that you do that, and this is my understanding, is you would null and void all the existing laws in the land that include the death penalty.
Oh, this is why people go to school for this.
I don't
Let
understand.
the purge commence.
But you're not going to be able to like re-alive everyone who's gotten the death penalty in the past. So
we're reanimating them. Yeah.
I guess my point is I guess you'd have to be like very specific in the ruling to say, we are handing down a judgment that includes the following: any law that contains language to the effect of the state has the capacity to punish you by death. the penalty of death shall be stricken. So
yeah, that's what I'm
there's
saying.
still a
Not-
crime, and all of these other penalties are still possible, but we're saying very specifically that like you can't do this particular penalty going forward.
yeah, that's kind of what I was thinking. If we can do that, that's actually where I'm leaning. I don't know if that actually answers the question we're here to answer, but
Well, the fun thing is you get to answer. We bring you a question, but you get to answer
Yeah.
whatever one you want.
Yeah. Again, this
Yeah.
is our court. This is our rule. It's our kingdom. We're ruling it poorly, but we're trying. I feel like we already have an answer to the question. Like, I feel like the answer to the question is, well, at least Chris and I are on this. Like, is his guilty plea invalid, even though he asserted that he's guilty? Sorry, that he's innocent and he's only pleading guilty to avoid the death penalty. No, I don't think it's invalid. I think he saw all the options that were against him. He saw the evidence that was stacked against him, and would frankly rather rot in jail for 30 years than die. I mean,
fair.
Or
You know.
risk death at a trial.
right,
Yeah.
right, or risk death. Correct. So I don't think it's invalid, but yes, I do
Yeah,
like the idea of protecting future innocent people, that like actually innocent people who are put in this position.
Yeah, I think I agree. We don't overturn his being guilty, but maybe we put a caveat in that, okay, going forward, the death penalty is not a viable penalty for these offenses.
I would sign off on that.
Do we want to lock things in? Do we want to do official? Do we feel like we can do official opinions?
I'm feeling pretty solid at this point. I wasn't 10 minutes ago, but here we are. Chris, where are we at?
Yeah, I think I agree, but I don't think his guilty plea is invalid. He was just trying to avoid the risk of potentially dying or getting the death penalty assigned to him by the judge. So I definitely agree that his guilty plea is valid, and he should be sent to jail for second-degree murder.
I have one actual further question before we lock things in entirely.
Ooh.
Is it possible, like, after, okay, let's say this guy, takes the plea deal, he goes to jail for 30 years. Like, is that it? Is that set in stone, or is there any way for like there to be some sort of like retrial, or for it to like be up for review again? Like, I don't know
This
how
is like his
courts
fifth
work.
appeal.
Oh, I guess that's what those all would have been. Yeah. All right. So
Well,
this
I guess
the last straw.
is it the same appeal, just up to different? Does that each one of those count as a different appeal?
Yeah, like after 15 years in jail, are they able to go back and be like, hey guys, like I've been really good. Can I maybe like not rot in prison forever? I don't know.
Well,
how
I
things
think
work.
So, like,
I think
parole?
parole is the technical term there.
Oh, well, yeah. Can he do parole? I don't know.
I have no idea.
I mean, he allegedly killed a guy, so maybe not.
I don't think that's a purview of the courts necessarily. That's the
Yeah, I think we're getting outside our bound.
yeah.
Excuse me for asking legal questions,
So
I've heard about you people and your jurisprudence.
he was sentenced to the max of 30 years. So I don't think parole
that's probably not a thing for him.
is an option for him.
That's fine. I was just curious. All right. Well, on that note, I am ready to lock in our decisions, if the
All right.
associate justices are too.
Yep.
I'm always ready.
Hell yeah. Cue the sound effect for us then locking in our decisions.
All right. Who wants to render an official verdict?
Michael, as our guest judge.
The court finds that, let me word this correctly here, his guilty plea is not invalid. He made this choice using his own decision-making powers in order to avoid a harsher penalty. However, going forward, the court recommends that the death penalty be taken off the table as a viable penalty in these matters to avoid potential issues of coercion.
As so ruled.
Mic drop. Literally.
Nice.
And Associate and Chief Justices sign on to that opinion full cloth.
I'm signed.
Hancocked.
Yep.
Man, Anonymous on my first time here. I feel like part of the club, guys.
Welcome.
Did you say
Don't get too
anonymous or
comfy.
unanimous?
Do I get a wig yet?
No.
You just
Damn
get a
it.
bunch of glow.
Yeah. You might get some cases of alleged apple cider vinegar, though.
I'll take it.
Barrels.
Barrels.
We do have roughly 95 barrels of alleged apple cider vinegar.
95
More or
barrels.
less.
Give it
Fermenting.
more or less.
More or less, yeah.
Wow. Okay. So for background, this case was argued November 17, 1969. It ended up being re-argued October 14th, 1970, and was decided November 23rd, 1970. So the final decision, it was 6-3 in favor of North Carolina. So in the main opinion that was written by Justice White, they did say that usually the conviction based on a guilty plea that's justified by the defendant admitting that they committed the crime and agreeing to a judgment without a trial. Although this person stated he did not commit the crime, he made his plea because there was nothing to gain from a trial in light of the evidence and a lot to gain from a plea. In his case, the second-degree murder conviction was better than a first-degree murder trial. He had a competent lawyer. The evidence negated his claim of innocence. Also, it was demonstrated to the judge that he knew what he was doing in entering his plea. He had also been consistently stating that he wanted the court to find him guilty without a jury trial. And the court had previously held that a guilty plea that was motivated by avoidance of a possible death sentence is not compelled under the Fifth Amendment. So they were like, he knew what he was doing. He entered this plea, so it's valid. They drew this parallel to the plea of nolo contendere, and in that, or no contest. So basically, in that instance, the defendant does not admit guilt, but they waive the right to trial. And they indicate that the court can treat him as if he were guilty. So they said that this is basically the same thing, although in this specific case, this guy was asserting his innocence. The court has held that the federal trial court, after a no contest plea, has the power to impose a sentence afterward. Therefore, the Constitution allows for sentencing a defendant who is not willing to explicitly admit guilt, but all things considered, would waive trial and accept the sentence. So the Constitution does not require an express admission of guilt to impose a sentence. So it doesn't make any difference constitutionally whether he pled guilty or no contest or, whatever. So that was their reasoning. The defendant can decide to plead guilty for reasons other than guilt, so they should be allowed to judge and make the decision for themselves. The individual can voluntarily, knowingly, and understandingly consent to a sentence, even if they are unwilling or unable to admit to the crime. So the standard in deciding whether to accept a guilty plea is whether the plea is voluntary is a voluntary and intelligent choice made by the defendant. So the trial judge did not commit a constitutional error. The Court of Appeals did make an error in finding his guilty plea invalid.
Well, there you have it. Isn't this called literally the Alford plea?
It is. Yes.
There it is. Oh, guys, I knew I was kind of a lawyer.
Or definitely some kind of lawyer.
Felt it in my bones.
I guess that's why you're the Chief Justice.
Exactly. Yep. Thank you, guys.
Yes. This is the so-called Alford plea. It's based off of this case. That was the 6-3 decision. The dissent, written by Justice Brennan, basically said, well, the court needs to consider the influence of threat and the denial of guilt on the voluntariness of the plea. And to them, basically, H.A. was so afraid of the death penalty that he basically made the plea under duress, according to the dissent. But
yikes. I mean, fair. I would be afraid of the death penalty. I don't want that.
Yep.
Yeah.
I mean, if you get a really rough or harsh judge, then, they could sentence you, because it's not guaranteed that you get the death penalty, right? It's up to the judge sentencing. But it does leave it on the table, put it on the table. So
Kind of sounds like the three of us are pretty much in line with the Supreme Court on this one.
Yeah.
Oh,
Oh, we're
yeah.
basically the law of the land at this point.
it's true.
This is power. I like this.
Yeah, right? Let it get to your head. Let it consume you.
And while you guys are feeling good, I'm gonna drop some other information. This is sort of the other. Yeah, no. So according to, so I just ran through the written opinion. What is also available is the oral arguments, at least the first, not the re-arguments, but the oral, the first one, the first time it was argued. There's like transcripts and recordings. And according to the transcript, one of the aggravating factors identified by HA's lawyer as likely to lead to the death penalty was the fact that HA, who was Black, was out with a white woman just before the murder.
Oh.
Oh, well, you didn't tell us that to start. I'm kidding.
What year was this?
So this was decided in 1970, and
The
the
actual murders were mid 60s?
1963.
Oh, even earlier.
1963. Yeah.
So how can we trust the testimony of the witnesses?
Exactly.
Unfortunately, they knew him, like a neighbor, like, yeah. So
Like he really was like probably like a really sketchy guy.
He did have a rap sheet that was supposedly extensive.
Okay.
Oh.
which would be like the, yeah.
But, at a trial, is that, is it probative or is it prejudicial?
Well, for sentencing, your history can be taken into account, and
Sure, for your sentencing, but not for
Yeah.
your adjudication of guilt.
yeah.
Adjudication, great word. I don't think we've used that one yet.
Fantastic.
I've learned a thing or two from my reading.
Yeah,
At most.
the witnesses, I'm just scrolling through and seeing, but I know there was a neighbor, there were a bunch of people who knew him, and at least one or two was trying to be like, hey, don't kill that person, and he was like, I'm gonna kill him. So and then in the end
I just want to say he was with a white woman, but he shot another Black man.
Yes.
Interesting. Well,
Shouldn't be
that
shooting
matters.
anybody.
I know, right?
Sure, right.
It's just like,
Why does that matter, Jarrett?
Yeah, Jarrett.
What the hell?
This is why Nikki wins. You lose.
He served 22 years of his 30-year sentence, and then he died in prison in 1975 at age 57.
Wait, when did he go to prison?
Let's see. So the murder was 1963.
So he was 35.
I don't know when
Well, I'm
he
just
was.
thinking, like, that's probably about as long as it would have taken for them to actually, like, bring down the death penalty, like, on him.
Yeah.
So
10 years. Yeah, 10 years of
yeah, he didn't even really
sitting on death row and appealing.
gain much. Poor guy. All that working for what?
I mean, I guess he didn't know he was going to die in 10 years.
I mean, that's fair. That's fair.
So I touched on it a little bit in my argument, but I didn't want to go like too far down the rabbit hole. But so when Nikki and I were talking about this yesterday, it's no secret that Nikki does most of the prep work and is very up on things. I think you can hear that in her arguments versus my arguments. So I kind of went through the research, and then I did a little bit of my own last night, and I was thinking about it. And my initial reaction when we were talking about it is like, I don't really have an opinion, if I'm being honest with you. I was like, if he did it and he was just trying to get away, just trying to avoid the death penalty, that sounds perfectly rational to me. I would do the same thing. On the other hand, I don't really love the idea of the state potentially having a cudgel to coerce me into doing a thing. But the more I thought about it, the more I started thinking about prosecutorial discretion and how many people are put into positions like in this case it was the death penalty, which feels really extreme, but but at the same time, every day in this country, folks are being put into the same position, but it's things like, oh, you have a minimum wage job that requires you to clock in and clock out. Well, I'm going to detain you without bail
Mm-hmm.
unless you plead guilty.
Mm-hmm.
And you could take an Alford plea, but guess what? Now you've got the record because you didn't have the resources to fight the state. And
Mm-hmm.
so the death penalty piece of this makes it really visceral and sort of just like, and the murder piece, I think HA is a very unsympathetic character in this narrative who makes it very easy for you to be like, what? No, that guy stays in jail. Screw that guy. But for me, the thing that started to creep into my mind was this feeling of like, the death penalty is not the only thing that the state can use as leverage to put you in a position of making the choice that they want, and there's really nothing you can do about it. And that started to kind of creep me out a little bit.
Just by having a record, you are subjugating yourself to, potentially not getting a job or, not getting a higher place in society just because you now have this cajoled record.
And so you could absolutely take an Alford plea, but it alters the entire trajectory of your life from that point out, and the prosecutors just get another win. And they don't have to prove anything. And like they could have a really weak case, but you literally cannot afford to go to trial. You can't miss work. You have childcare issues or whatever, right? And so tried to touch on that a little bit with the whole like this creates a have versus have not situation without going too far into prosecutorial discretion. But that was my takeaway from this, which is like HA, totally unsympathetic character. I'm cool with this guy getting locked up because the deck seems stacked against him from an evidentiary perspective. But then taking it to the next level or taking it back a step and saying like, but I don't know. I can imagine a lot of situations where people are essentially saying like, fine, give me a record, take your win. But like, if I lose my job, like I go hungry, I'm out on the street, I lose custody. Like there are just so many things that the state can do to you. And still the courts will say, but you had due process. And that doesn't feel accurate to me anymore.
I think pretrial incarceration is linked with, guilty pleas, taking plea deals.
So we should just nuke the justice system, is what I'm hearing. Start over.
The injustice system.
Yes, damn it. You made the joke before me. Damn it.
Sorry.
Faster, Mike.
I couldn't unmute fast enough.
And then I would also point out, so this is an Alford plea specifically versus, a regular plea deal. And so there's been a lot of kind of discussion about this by legal scholars. So it's sort of seen like this hybrid plea. So the defendant can maintain innocence while taking advantage of a plea deal, that would normally, require an admission of guilt. And so on the one hand, it can be seen as a benefit because you can, get a more lenient sentence. It eliminates this ambiguity of not knowing what the sentence is likely to be that you would get if you went to trial. There's also discussion about how it may actually remove incentive for defendants to lie to their lawyers and in court about their guilt and innocence and allow for their lawyers to represent them ethically. And then a lot of discussions about this plea also mentions shame and embarrassment. So this plea saying, I'm going to take the sentence, but I'm innocent, it allows people to save face and like avoid admitting guilt in front of their families. And so there's a lot of discussion about this around drunk driving and also sexual offending. So it's like, I'm just going to just move to the end and not have this long drawn out thing. I'm going to just, whatever. But then on the other hand, there have been some downsides, and this has been explored by Brian Ward in an article he wrote in 2003, because there's all sorts of, I guess, hidden consequences that are really specific to the Alford plea. So when the judge is deciding on a sentence, one factor that can reduce a sentence, so make it more lenient, is if the defendant is like expressing remorse and like taking responsibility. But if a defendant is like, I'm innocent, I didn't do shit, then that's going to come off as a lack of remorse. And then if they're subject to probation or parole or being considered for like parole, when you're gearing up for a parole hearing to kind of get out of prison, there's also this expectation that you take responsibility. And how's that going to read if the defendant is like, I'm innocent, I'm innocent? It can cause problems if the person is engaged in like court mandated counseling or treatment that requires an admission of an offense, which comes up a lot when you're talking about treatment related to sexual offending, where the person is supposed to really sort of own what they've done and the harm that they've caused, and to move forward in treatment. And if they're not doing that, then that's a problem. So Ward, in his article, makes this point that the person who most benefits from the Alford plea is the defense lawyer. Because then the person, they're like, oh, I'm innocent. And then it's like, sure. But just take your guilty. And like, we're just going to move on to the next.
Yeah.
Fishy.
Yeah. And then Stefanos Bibas in a 2003 article also points out that they take this abolitionist stance, and say that it's a problem because if somebody who is innocent uses this plea, then there's this perception that they're being pressured into pleading guilty. If somebody who's guilty uses this plea, then they avoid accepting responsibility for their behavior, and that prevents victims and society from getting acknowledgement of the harm that was done. And so this kind of plea and the no contest plea, quote, permit equivocation, ambiguity where clarity is essential. So according to his reasoning, this might be why, even though federal law allows for Alford pleas, federal prosecutors and judges may or may not even accept them. U.S. Department of Justice policy, I think, discourages it. It can vary state to state. So some states allow them, some states don't. And then even, some prosecutors' offices accept it, some don't. And some defense lawyers, will accept this plea. Some will absolutely not let their clients do an Alford plea. So this case sort of like answered the question, but I don't think I don't know if it settled the matter. I mean, maybe, I'm not a lawyer. I don't know what the, legal scholarship says, but it doesn't really seem like it's like settled the matter, but it is available.
It does seem very all over the place.
Yeah.
Okay, if you're somebody who like takes an Alford plea,
mm-hmm.
and you, for like a silly crime that maybe you didn't even do, and it's on your record, like, does your record show anything to indicate that it was an Alford plea specifically? Maybe you can explain to a potential employer, like
there's an asterisk, like a home run record for someone who was on steroids.
Yeah, guilty of these crimes, like.
See footnote.
Alford plea.
Yeah. I actually don't know. And then if you were the employer looking over somebody's sheet and the person like served a sentence for a crime, does it matter to you? Like you're just,
I don't know.
or is the employer just going to be like, oh, he did time, or he was, sentenced to probation or whatever, I don't know.
I don't know. We're not lawyers.
Oh yeah. No. Hell no.
Some of us might be employers, though.
Speak for yourself. Maybe.
I am.
I employ myself occasionally.
There you go.
Have we thoroughly depressed you all or made you question everything you thought and believed?
Yes,
I was
Jared.
already doing that.
I'm depressed.
Well, I don't think Sarah was I don't think it changed anything at Sarah believes, because she was like, isn't this an Alford plea? Isn't this the case?
Yeah, it did creep up. I was like, I've heard of this.
For those unaware, Sarah has taken several Alford pleas in her life.
Yeah, nobody look at my record.
Jesus.
All those murders.
Alleged.
Hush now. If you're my boss. No, I didn't.
You don't get.
And if I'm not your boss,
Probably didn't. I'm innocent.
So I am curious, in light of everything we just discussed, how do you feel about your judgment?
like just generally, like my character, or
Yeah,
I mean, we are starting to get a sense of it, but just the specific judgment.
I feel okay. I think we sent the right guy to jail. I don't think he was innocent. I don't think we can solve the rampant problems, but we should. I mean, arguably, the court's job is to ensure the state isn't suddenly, taking your rights to a fair trial and things like that by coercion. But if you did something wrong, there should be some checks and balances in place in our system that's like, yeah, maybe you shouldn't kill people, or else you might die, potentially, if you're a jerk about it. And so I just
can't be a jerk about it.
Yeah, can't be a jerk about it.
You're gonna kill someone, like, at least don't be an asshole.
Yeah,
be respectful, okay?
I mean, there's being a murderer, and then there's being like just a dick. Like,
Here's the difference for sure.
Yeah, that's where I'm at. I feel okay. I feel fine.
Yeah, I feel like I could feel better, probably.
Yeah,
but
I recognize some of the issues, but given that I am not a judge and this is my first time doing this, I'm okay with my decision.
Yeah, I'm glad that at least in our little imaginary courtland, we abolished the death penalty, so people can't, if they're faced with this situation, they can actually consider going to trial and proving their innocence without fear of, dying like 3 years later from lethal injection.
I mean, we've solved at least one problem, so come on, give us that.
Yeah, I mean, we're tired, okay?
In the real Alford case, they didn't overturn the death penalty.
That's so we're winning.
It's gonna be very awkward in future seasons because y'all, there are so many death penalty cases.
So many. There's like a lot.
So
future generations where it's like
if you can use this as precedence, can't you just like automatically just
toss it out?
Yeah.
So this is really shortening up some of the future episodes pretty significantly. So that assumes that future justices that we have on the show don't overturn your precedent. This is the Sarah court decision, but someone else could come in and just be like, nope.
Someone might really deserve it,
Oh, see now.
I mean, I don't
be saying that.
You know what? Bring it back. Never mind. It's tiring wearing this powdered wig. Have we said jurisprudence yet this episode?
Yes,
okay.
100%.
There's definitely been
Mike
at least
brought it up.
one. Yeah.
Oh, okay, good. All right.
You're welcome.
We're good.
Yep. Nikki, I think we can close it out. I think we're all sad.
Yep. All right, good.
Certainly.
That means that we we did our jobs. That's the point of it all, right?
Yay, justice.
to be depressed.
Yay.
Can the next one be about like zebras or like crop law or something?
I'm telling you, food cases.
It is 100% possible that the next case could be about any of those things.
Yeah,
Ooh,
actually.
good,
Will-
good agriculture case.
Will the next case be about any of those things? You're just going to have to like and subscribe and
no.
listen.
Link in bio.
Link in bio.
Yeah.
Sponsor us. Maybe.
All right. Now that you guys have been appropriately saddened, I think that means that we have done our job. The court sort of overturned the death penalty and short circuited just a whole line of death penalty jurisprudence. But yeah,
We
Go
get shit
team.
done, man. You know, we've like changed. It's like a new timeline now.
Yeah.
Right? Like all
Ooh,
those
yeah.
other cases just disappear.
It's a new branch.
Awesome. Well, thanks to everybody. Thank you to Chief Justice Sarah, our Associate Justices Chris and Mike, who is donning the powdered wig for the first time. And yeah, this has been relitigated. Any final words, Jarrett?
Nope. Have a great rest of your day.
Cue the sound effects.
Or afternoon, or
after, yeah.
morning, or
Yeah.
Evening.
middle of the night, or
Have a good time. Yeah.
There it is. And scene.
Bye.
Ciao.
That was North Carolina v. Alford. In summary, the Sarah court decided that H.A.'s guilty plea is valid. They also overturned the death penalty while they were at it. That's it for this episode, but before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Audio mixing and producing was done by Jarrett. Thanks for listening. Please subscribe, rate, and comment so other people can find us. You can also catch us on YouTube and Instagram at Relitigated Podcast. Help us spread the word. Until next time, I'm Nikki, and this has been Relitigated. Bye.